We all collectively welcome and thank you for taking time out from your busy schedule for this interview. Sir, if you let me, can I give a brief introduction about you?
Go ahead. We're not live yet, are we?
No, sir, it's for the participants who've joined, the other people in the center.
Sure, of course. Go ahead.
So, Sir is an alumni of the National Law School of India University. He is a batch of 1998 and he has been a practicing litigator in the city of Bangalore since his graduation. He has completed his
Bangalore
MA.
and Delhi. Yeah.
Bangalore and Delhi. He has completed his MA in Political Science from Bangalore University in 2006 and has obtained a PhD in the same subject from Mysore University in 2013. Since then, Sir has been designated as a senior advocate by the Karnataka High Court in 2014 and has also had a brief stint as the Additional Advocate General for the state of Karnataka from 2016 to 2018. Sir, with respect to your introduction, would you like to add anything further for our readers?
No, that's fine. That's fine.
Okay, sir, moving on to the questionnaire. The first question is, please tell us something about the factors that motivated you for taking up law in your pre-college days.
Mother, just to understand, you'll be recording these questions and then editing the talk and then going live, is it? Is that how it works?
Yes, sir.
All right. Would you repeat the question once?
Sir, the factors that motivated you for taking up law in your pre-college days.
Well, actually, I never intended to join the profession of the law. You're asking me in my school days, pre-college days?
Yes, sir.
Oh, yeah, absolutely. I mean, I'm an accidental lawyer, as I've said publicly. I never intended to join the law. It's just that I had heard that there was a good law school in Bangalore that had come up. That's the National Law School. It was pretty new back then. In 93, it was only 5 years old. And that kind of got my attention as a good option if I was going to stay on in Bangalore. I had plans to go overseas actually after school, but those didn't materialize. I was lucky enough to get admitted to the law school, and as a result, I stuck it out. So there were no real plans behind that decision.
Oh, okay, sir. That's not what I was expecting. Sir, moving on to the next question. In one of your interviews, you said that most of your capable juniors are not from national law universities, but from traditional and local law colleges. There's a second part of the question. What should a law student incline towards litigation as a career path do to become a good junior and a good lawyer, as per your opinion?
Yeah, they're two very different questions. Let me take the first one. I said that some years ago. And yeah, it's a fact that most of my juniors have not been from the NLUs. I've had some very good juniors from the NLUs too, but I would say majority of my juniors have not been from the NLUs. Certainly not from NLS. I must have had at the most maybe 2 or 3 from NLS who worked with me. And of that block of juniors who were from the university law colleges and the government colleges or the local and other private colleges, I found that they had a better commitment to the chambers. That's not to take away in any way from others who've done very well with me. But yeah, I think I can generally say that I have found overall that the temperament of those belonging to the non-NLU category has been better suited to practice. I found them more open, less prejudiced. I found them willing to learn and work harder. And to be honest, I've just found more of them joining my chambers. Maybe it's a function of that. And that might correlate to the fact that less products of the NLUs tend to go to the bar. That was the case when I joined in 98. I don't think that has substantially changed. It might have changed marginally over the years. And as a result of that, I would suppose that many chambers tend to have more juniors and therefore, as a result, better juniors from the non-NLUs. I don't have statistics on this, but from my experience, if there's one thing I've noticed generally is that the products from the NLUs at times have either come with too high an expectation or wanting things to happen too quickly. And that's slightly unrealistic when you join the bar, because there will be disappointments, things will take their own course. And most of all, you will have to earn your stripes. And that takes a certain fire in the belly. And I think that is the difference. What was your related question, please?
Sir, what should a law student, let's say in an NLU, incline towards litigation as a career path do to become a good junior and a good lawyer?
Oh, I mean, NLU or otherwise doesn't matter. The first and foremost requirement is that you need to be as sure as you can in your head that you want to practice. If you're sitting on the fence, then practice is not for you, because it's rough to begin with and you will get too many unpleasant surprises at the start, and that can bog you down. So number one is to have a 100% clarity in your mind that you want to practice. If you have that, you've already hit the ground running. Over and above that, yes, good internships. You should ideally be able to intern in a chamber that you're going to join, so you already know what sort of work ethic, style of work, type of senior, type of colleagues you're going to be working with. That gives you some comfort and a head start. Beyond that, I mean, you really learn on the job. I think your question itself suggests that NLU products are a separate class, Article 14 classification. In my mind, they should not be. It doesn't matter. Once you join a chamber, the first thing probably you should then do is forget that you're from some NLU. At least when I joined my senior, it made no difference where I came from. I knew very little. I suppose I was honest enough to accept that I knew very little, and I knew I had to learn everything about the practice on the job. So I think sometimes this baggage or these tags that come get stuck in your mind. You think you're cooler than others, or you think you're smarter than others, or you think you have a better looking CV and so on. Honestly, all of that really doesn't matter when you're in court. It's advocacy, it's a practical application of the law, it's hard work. Those are the things that will actually set you apart in a marathon, So these I think are the fundamental prerequisites that you should have when you start with a chamber, and you have to be willing to learn. You will be delusional if you think that your grades in law school will measure up necessarily to your performance in court. That's not the case at all. It might, in terms of you having a good work ethic, it might in terms of having good research skills, but beyond that, advocacy is strategy, advocacy is drafting, it is client interaction, and most importantly, it is oral submissions in court and response to questions under pressure, which needs a very different skill set and a temperament, which honestly you can't really learn in any law school. You may be exposed a little more somewhere or a little less somewhere, but at the end of the day, court is a real space. Even moot courts don't replicate the pressure of real-time court. And if you can have that attitude, I think the bottom line is the attitude. If you have that going, then you'll do well at the bar.
Sir, I framed the question towards the NLU students because you said they had a certain prejudice when joining the bar. That's why I changed the question a bit.
And I think I answered that as I went along.
Yes. Yeah. So moving on to the next question. Sir, how can a fresher in the court of law improve his or her argumentative skills, and what is your advice for them?
How can the pressure in a court of law?
Let's say in the bar, sir. Yes. Enrolled in the bar.
A fresher, you say?
Yes, sir.
How can a fresher enrolled at the bar improve his or her performance?
Argumentative skills, yes, sir.
Argumentative skills, yeah. I mean, part of this answer I've already given you as to what a fresher should bring to the table. But if you're specifically speaking about oral arguments in court, I think the first thing you need to do is wait your time. A lot of juniors make this mistake of thinking that if they're arguing cases from the very first day, they have their nose ahead. that can be slightly counterproductive and counterintuitive, because oral submissions come also with a degree of comfort and a degree of experience as to how courts work. So you don't just show up there and start, rattling off your brief, because you're before a judge or a bench, you have opponents against you, and you have to factor all that in, which takes some amount of confidence and experience. So the first thing I think is to observe your senior, watch responses to questions. I've always said this, that advocacy is not a monologue, it is response to questions that come to you from the bench. If you can answer questions well, you're a good counsel. If you're not answering questions well, however well prepared you are, really makes no difference, because you're not going to get the order. It's situational. You need to be able to study situations to see how much to say, how little to say. You need to, in an admission matter, for example, you have to make your best 2 or 3 points. You don't have to argue the entire matter. And all of that, I think, comes with a bit of experience. I have said publicly before that your best bet in the profession is to be arguing cases from the start. So I would caveat that by saying the start doesn't mean day one. You still need to give it a fair amount of time. I wouldn't put a cap on it, but you need to watch. You need to watch and learn. Take it slow and give it time to warm up as well. I mean, don't go to court expecting your first appearance to be grand. My first appearance, I could barely open my mouth because I was, I don't think I was intimidated. I think I was over-prepared. I still remember that day. I may be digressing a little, but I'll tell you anyway. It was a case where I was appearing, I think, for the UGC, if I remember, and my senior had given me this brief, which was actually on my first day after I completed my apprenticeship. And I was up against a former advocate general. And I had prepared my case, I thought, to such an extent that I didn't know where to begin. And that is exactly the lack of experience that I'm talking to you about, because before an experienced judge, you don't have to, and I was before Justice Ravindran, who's one of the best judges our Supreme Court and the Karnataka High Court has produced. Now, before a judge like that, you don't have to go and start from ball one saying the petition is not maintainable because of locus standi and cite 8 judgments on it. Those principles are too well known. So, long story short, what I'm saying is, courts expect you to argue on first principles most of the time. Case law, etc. supports your arguments. So try and develop a strong first principle advocacy base. It takes time. It takes a lifetime. I mean, we're all work in progress. But once you get that bit of initial confidence and comfort, then I think your oral advocacy can take shape. And importantly, keep speaking to people. Don't think you know it all. You will make mistakes. You will be sometimes guided by judges. Sometimes you will be chided by judges. So you need to take it on the chin if things are not going your way. And I think these are some of the pointers that would help.
Okay, sir. Thank you. So moving on to the next question. Sir, as mentioned earlier, you did your MA in political science after you enrolled in the bar. How far do you think it is necessary to have a graduation in one social science subject to excel in litigation, let's say especially in constitutional matters?
Look, I did my, not just my MA, I also did my PhD while I was practicing. And I did those really not with an eye on my practice. In fact, I wanted a constructive distraction. I never thought I would miss academia, considering how unacademic I was in law school. But at some point, I started feeling this urge to get back into scholarship. And I also had more time on hand because I had just set up my independent practice. I didn't have much work to do. So I had the luxury of a little more time to be able to pursue my master's and my PhD. And I really, therefore, did it out of the intent of trying to expand my mind and be exposed to a completely new stream. As you may know, my PhD was on civil-military relations in India and Pakistan. And I never really did that looking at my profession in any way. But in hindsight, having gone through it, I can say a couple of things. I think one, yes, an exposure to a humanities course does help, especially as you said in public law, constitutional law, because the interface between politics, political science, constitutional law, and public policy, I think, is integral. So if you do have some scholarship there, it certainly helps you approach cases laterally. I think the second and more important thing is that doing your master's and more importantly your PhD, I think teaches you a certain academic regimen which initially the practice may not. So I find, having written my thesis, struggled with it actually because I really didn't have time towards the end, having slogged on research and writing and the sort of things, scholarly writing, which you don't do when you come to the bar generally. I found all of that developed a better discipline in me. And today, if I have to deal with a broad spectrum public law issue, something like the hijab matter, which I recently argued, just by way of illustration, I found that having this experience or this discipline certainly helps you go deeper into matters. It helps you research more broadly. It makes you assimilate writing on the subject better. It makes you a little more analytical. And that, in hindsight, I found is a certain advantage of having gone further and done my master's, which, by the way, I did through correspondence. It's not that I was able to take time off and go away. That's not a luxury a first-generation lawyer has. But yeah, even with the correspondence course and then my PhD, I think this dimension was certainly helpful.
Okay, sir. Thank you so much. Moving on to the next question. What advice will you be able to give to an aspiring litigator as to whether he should join a litigation firm when starting up or a chamber with a chamber of an advocate? Which one will be better suited for him to gain more experience at the starting of his career?
Him or her?
Him or her. Yes, sir.
I'm always in favor of chambers. There's no two ways about it. There are some very good counsel who come out of law firms as well. I'm not taking that away. But I think often with a law firm, it's a bit of a toss-up because you need to get it right in terms of which partner you're working with and whether that law firm is a court-facing law firm. There are law firms who essentially draft or brief seniors, and there are those who conduct their own matters. And there's a world of difference in the manner both those practices are conducted. Whereas with a chamber, especially if you're with somebody who is not a designated senior, then your exposure to the profession, I think, is more court-facing, it's more real, it's more hands-on. It's certainly tougher because you will make less money in a chamber than you will in a law firm. But I do believe if you get the chamber right, you get the work, you have a body of work that's given to you, you get opportunity to argue, which may not always be the case in a firm, because you must remember that law firms typically get bigger corporate clientele. And with bigger corporate clientele, I don't think a partner can easily delegate a brief to a raw junior. In fact, many times partners would not be able to even argue cases themselves, even if they want to, because the client may have a string attached, which is that you must brief a senior in a case. So those are the things that may sometimes distance you from the real advocacy. And therefore, I think overall, the likelihood of you getting more exposed to all of those things I said earlier that come with the practice, the drafting, the client interaction, conducting evidence, cross-examining witnesses, arguing matters, learning procedure. I mean, we don't even talk about that. Your best teacher, in fact, sometimes is your clerk, because a clerk knows how a file is actually finalized and filed and brought before a court. Trust me, that's not an easy process. And if you're unable to get that right, how will you run a chamber in the long run? So I think any place where your learning is more direct, is less either delegated or cushioned or cut off from you, is better, because you really join a chamber to learn and then move on. At least that's been my mantra, that you join a chamber and you move on and set up your own practice. I didn't personally have a plan of action as to when I would leave my senior, or if I would leave my senior, even because I was, as I said, completely new to the profession and fairly clueless to begin with. But now, with these years of experience, I can say that that is the right model to follow, which is to join a chamber and then go on and set up your own practice. I believe that's the more pure form of litigation. But I must tell you that things are changing. I think firms have begun to do more litigation work now than they did even, say, 10, 15 years ago, especially when it comes to slightly vertical practices. It could be, competition law, it could be tax, it could be arbitration, commercial practice, essentially. And I think there, the quality of work that firms get is many times superior. But it's the skill set, it's the initial skill set and the confidence that you gather that I believe matters more than the profile of the clients that the office has. And if you want to be exposed to pure civil work, criminal work, writ work, constitutional law, etc., I think you will have a better shot at it if you're with a private chamber.
Sir, as a continuation to that question, when somebody, let's say a fresher, is enrolled at the bar, do you think he should join a chamber with, let's say, practicing before the appellate courts or the trial court?
He or she.
He or she. Sorry.
I think it's a personal choice. It depends on what really gets you interested. I think it's very important in your years in law school, especially probably your 3rd to 5th year, in the course of your internship, to figure out what type of practice interests you or excites you. I think that's very important. You have to be excited to be joining the bar. Only then will you be able to take those body blows and move on and enjoy the process. Otherwise, every hurdle will sort of pull you down. If you are more attracted to evidence, cross-examination of witnesses, procedural practice. Look, procedural practice is not bereft of theory. Procedural practice has a lot of strategy and acumen behind it. Some of the sharpest lawyers are trial lawyers. So if that's what excites you, if it's criminal advocacy, defense lawyering, then the trial court is for you. But if you're more inclined to say, the writ side of work, then obviously it's the High Court. Now you said appellate practice. In a way, original and appellate practice is a bifurcation that the courts with, the original jurisdiction, the demarcation. And that's a question you should put to somebody who practices there. But if you look at the Karnataka High Court, where I've practiced most of my life, if you're an original side lawyer, then you're a trial court lawyer. So you need to make that call. There are different territories, there are different types of cases, and they have different skill sets. And I think it largely depends on your interest. I will add to that a caveat that you certainly must have some trial exposure. Even if you're inclined to be, as you said, an appellate lawyer or a writ lawyer, or you want to practice directly in the Supreme Court, if you are not exposed to the way cases begin, if you don't know what the genesis of a case is, how it becomes a case, how a lawyer decides to file a case in the first place, which court to file it in, whom to make parties, what relief to seek, what applications to file, etc., you will be half-baked. And then your role in appeal will be limited to pointing holes in an order of the trial court or of the High Court if you're in the Supreme Court, but you'll really have no gut feel on how this matter is actually to be conducted. So I will caveat my answer by saying that even if somebody is more interested in being in the High Court or being in appellate practice, you have to be able to make time to do trial work. It's not easy. I had lesser trial exposure in my early days. I tried to make it up later. But I know for a fact that That is a very integral part of a complete package as a lawyer. You need to have that instinct, and you also need to have that pleasure. If you're not doing cross examinations and so on, you're seeing a smaller side of the practice. Let me put it that way. You're missing one of the most interesting facets of practice, which is evidence. The thrill of cross examining a witness, eliciting answers, driving home a case, the ability to not be argumentative and only put questions. And remember, you don't put questions from a questionnaire, you put questions on the spot depending on the previous answer that a witness has given. You may have 100 questions to ask. There are cases where in an arbitration I've had 300 questions prepared by my briefing counsel, but you don't go from question 1 to 300. If the response to question 1 requires me to ask question 297, I should be able to do it then. And when you get that right, it feels good. When you get a good answer, it feels good. And that's a completely different skill set. You'll never get that in appellate work. You'll never get that in writ work or in the Supreme Court, right? So you have to keep an eye on that. Regardless of your choice, you must, I think, test and taste what original side advocacy is all about.
So moving on. Thank you, sir. So moving on to the next question. It's a related question actually. How would you encourage people to take up litigation as a career, especially since it demands years of patience and hard work as compared to corporate jobs which offer a lucrative annual package?
Look, law students are not minors, they're adults. They're supposed to know what their life choices are. Maybe not all. You figure your life choices out on the way, but I don't even think you need to be encouraged. At the end of the day, if by the time you're out of law school and you're not drawn to the practice, so be it. There may be greener pastures. It's your call ultimately. So, I mean, maybe in my earlier years, I was a bit more of a cheerleader for practice and I used to try and pep talk people into it. But today I feel at the end of the day, this is really a decision that has to come from within. Your first question to me was what motivated me to do the law. I told you it was an accident. But a related question to that could be what motivated me to join the bar. And by that time, I was no longer a straggler in the sense my CV was ordinary, but I had one clarity in my mind, which is that I wanted to practice. I didn't sit in on recruitments at the law school. There were very attractive offers that my classmates were getting. Of course, many of them were far better accomplished than I was. But I chose not to go down that route because I just knew instinctively that joining the bar is a choice of an independent mind. To me, even as a 22-year-old, that mattered most. It meant whatever I do, I will do on my own, make or break. And I will be able to control to the extent possible my ideology, my independence, my intellect, my lifestyle, etc. And I think that is what made it crystal clear to me that I wanted to practice. I didn't need or nor did I get any encouragement or pep talks in that sense. I did a few internships. I thoroughly enjoyed an internship in Delhi with Mr. Dipankar Gupta, who was then he was the former Solicitor General. I saw what the charm of the practice is. I joined my senior's chamber, Mr. Holla, as an intern. I slogged with him. I think I had a good working rapport with him as an intern, and I asked him to join the chamber. Nobody gives it to you on a platter. And I remember even now that when I asked Mr. Holla if I could join his chamber, he said, yes, but where will you sit? And it was a valid question because there were no seats vacant for another junior. His chambers were full. And I said, sir, I'll sit on the client's chair. And I remember for the first many months probably, I used to sit on a client's chair facing one of the senior colleagues. And if clients showed up, I would have to make way for them. So look, encouragement is fine. You can listen to conversations from other lawyers, you can follow them, etc. But I think more than encouragement, it has to be an internal decision that you have to make. because it's a very real choice. And the second part of your question was, considering the fact that it's a difficult choice. So, you can hardly encourage somebody to do something difficult, right? The human mind is not trained that way. If you want me to, I'm in Delhi now, I have to go somewhere shortly. It's raining. I have a choice to either take a cab and get there in 10 minutes, or I have a choice to walk in the rain and get there in 45 minutes. The latter is the tougher choice. Now, how much can someone encourage me to take that choice, right? They may tell me it's good for your health, or the weather is nice, I won't buy it. Whereas if supposing I'm one of those outdoor people who feels that a jog in the rain at 2 p.m. is a great idea, then I'm motivated to do it. I'm not encouraged. So I strongly believe that is the state of mind you should have by the time you're out of law school. If you don't have it, I'm not sure how much encouragement will help you go further.
Thank you. Moving on to the next question. Considering the fact that you have more than 20 years of experience,
almost 25 now.
25 years of experience now, could you briefly take us through one of the most memorable and interesting cases that you got to work on?
I mean, if you ask me the most memorable and interesting, there's only one actually that comes to mind. I mean, of all probably the hundreds of cases one has done, and each of them has its own fascination. But there's one that really springs out to me, which is a public interest litigation I did relating to intelligence reforms in India. It was a PIL filed in the Karnataka High Court and subsequently transferred to the Supreme Court, filed at the behest of a former intelligence officer from the Intelligence Bureau. And I remember he had approached me with this matter through a professor, with some writing he had done on the subject, where he identified a complete vacuum in the Indian Constitution when it comes to intelligence agencies. And in fact, when he told me that, I refused to take it at face value. I said, there's no way that the Indian Constitution would not regulate something this important. But he was right. I thought it was a civilian who didn't know his law. But when I saw his research, he was spot on. And we found that there was a vacuum in the law. There was zero, forget about regulation. There was no reference even to intelligence agencies in the Constitution or in the law, except for a stray reference in one entry in list 1 of the schedule, with no legislation to follow. And considering the legitimacy that intelligence agencies deserve and the nature of powers they exercise, we felt it was a fit case to take up. And that strikes me as a very fascinating case to have done, because it actually ties in with one of your earlier questions, because that is not a case you approach purely legally, in the sense your lateral learning of the way national security apparatus work, the way comparative constitutions work, the way comparative systems work, the nature and role of policy regulation as opposed to the need for more freedom to be given to intelligence agencies. All of this takes you beyond pure law. It takes you into very interesting areas of policy, politics, etc. And I found that this was a case where we really needed to go lateral to try and make out a case, not to mention the sensitivity of it. And yeah, that strikes me as perhaps the most interesting matters that I've worked on.
Yes, sir. Thank you. Moving on to the next question, sir. Has a bit of a personal bias as well. What qualities do you look for in a fresher before accepting him or her as your intern/employee, and what should one do to inculcate these qualities in law school?
Yeah, employee may be the wrong word, but as a chamber junior. And it's not just nomenclature. I think it makes a difference in terms of your engagement with the office also. That's something I should have said when you asked me about law firms, because the other thing with firms also is that there's a far more commercial side to it, if I may say, which is absent in chambers. In some ways, it's a charm. Sometimes it's not good for juniors also. If you make absolutely no money in a chamber, then it's unduly difficult. So you need fair seniors to work with. But to come back to your question, what does one look for? Well, different things at different stages. Now that, ever since I became a senior counsel, my requirements from my juniors have changed. Prior to being a senior, I needed juniors who had an aptitude for the practice, and by and large, they were juniors who had interned with me, so I already knew their work. So they needed to have that confidence to go to court. A lot of my trial court matters used to be were delegated to them. They used to appear. So I needed people who could take those matters head on. And I must tell you, the women juniors in my chambers have done very well on that front. And you needed juniors who had that that interest in going to court, who wanted to go to court, who didn't want to stay in chambers. And once you see that aptitude and that sincerity to want to go and practice, I think for me that was the bottom line. Everything else juniors would pick up along the way. And of course, rank honesty. I don't think any senior would tolerate a junior who's not honest to the chamber and ethical, and that's something that's very important. But as a senior counsel, my expectations now are a little different, because as a senior, obviously I cannot delegate briefs to juniors to argue, and I depend on juniors more for either making notes on the briefs to brief me, or more importantly, research on the files that I'm required to argue. And therefore nowadays I try and pay more heed to that. It helps to have juniors who've got a bit of experience behind them, because then their ability to read and understand a file is better, which helps me as a senior. If I have a junior who's done 2-3 years somewhere and they are able to read a file, come to the crucial points that need to be highlighted, I think that's a real asset. Because as a senior, I can read my file and make my own notes as I do. Or the briefing firm or the briefing counsel will brief you. But if a junior can share that load, and especially under pressure, supposing a brief is given to you sometimes the night before or sometimes even the morning of the case, you need somebody to be able to read through hundreds of pages and come to that central point in the case vis-a-vis a particular annexure or a document and identify the legal issue involved there. That's a tremendous sharpness that is needed. And if somebody has that skill set, which you don't have at day one, if they have it with a couple of years of experience, that's also something that adds value. And yeah, so these are the things that I look for these days.
Thank you, sir. Moving on to the next question. What advice would you give to students like us who are passionate about pursuing a career in litigation?
Oh, I think I've already answered.
Yeah, you've covered that, sir. Sir, may I ask a question off the record?
Yeah, absolutely. I haven't prepared for this interview, I can assure you.
Sir, recently you had withdrew your name from the elevation to the bench. May I ask, was there any particular reason involved for you to do so?
I've spoken about it publicly, Madhav, and you can read about it. I've done several interviews around it, and my views are in the public domain, and I have really nothing more to add to that.
No. Thank you, sir. It was a very wonderful session, and as mentioned earlier, we really appreciate you taking the time out of your busy schedule for this interview. I'm sure the readers of this interview will find your insight very beneficial in their path towards a career in litigation. Thank
you for having me. I think Ria has a question.
Yes, sir.
Yes.
Sir, so you mentioned that you are also a first generation lawyer. Sir, I wanted to ask that what are the struggles that you faced as a first generational lawyer, and what is one advice that you would give to your younger self, if you could give it now?
Yeah, I like your second question. I'll answer that first. What advice would I give to myself? I think it would be to take things a little easier. I think I took too many things personally at the start. I think I was at a sort of a heightened state of, absorption, which is great in a way because you learn more and take in more. As a result, you also enjoy your victories in court more when you get an order. But I feel I was also sometimes hypersensitive to things not going my way, and I took a lot of them personally when I needn't have. So I could have actually taken things a little lighter. Now that I see it with hindsight, 25 years into the profession, I realize this is a lifetime profession. You're not meeting targets. And if it means pacing yourself a little more, going easy, I made that mistake. For example, I took my eye off my health, for example, right? When I was practicing earlier, I put on far more weight than I should have. I was not eating healthy. I was not exercising. I was not resting enough. And it was just 100% the practice. And that's good. It's also necessary because it comes with the stress of being first generation, but it takes its toll. And sometimes it even takes its toll on your relationships. And I've been through all of that. And therefore, yeah, in hindsight, maybe I should have balanced things out a little better. And that would be my advice. As to your question, as to the disadvantages, you asked me, isn't it, of being first generation? Yeah, I think the obvious disadvantage of being first generation is you have no guarantee of having work when you go independent. That to me is the biggest issue with being a first generation lawyer. Everything else is okay. I actually feel being first generation in a funny way compensates for all the other struggles you face in court because you come with a greater drive. You have no security net. You can't fall back. You also don't have the pressure of a parent, right? Often sons and daughters of famous lawyers find it difficult to make their mark because they're in the shadow in many ways. They're perpetually being tested or looked at with a reference to how their parents were. And that's not easy. And being first generation, because you have no security, nor do you have these complexes to deal with, is to your advantage. But I think the one major issue is when you go independent. And I felt it. This is from my experience. When I set up my practice about 5.5 years after being in a chamber, I was shocked to find how little work I had. And that's not something I had bargained for. Ideally, I should have kept that momentum or built on that momentum. When I say momentum, obviously in your seniors chamber, they are not your briefs. So you're starting with a clean slate. But at least momentum in terms of making appearances and staying engaged with the law. Your mind needs to stay engaged. And there, I found there was a big gap when I went independent. And that was largely because of the fact that I was first generation. Obviously, word goes around, if you're good, the work will come. You will find feeder zones from unexpected areas. People need good lawyers. People need honest lawyers. So work will come. It's not a long-term problem. But in that short term, when you set up, I think that is a key disadvantage being first generation if you don't have a chamber to fall back on, because what it really does is it keeps you away from court. And I hated that the most. I set up my chamber so that I could go to court every day, try and do cases every day. Whereas for many, many months when I started, there were times when I was going to court once in 2 weeks. I was going once in 3 weeks, and that was extremely frustrating. And with that comes, non-litigation work, which you do because you need revenue, you need to sustain your chambers, but that's not the most exciting work to do. And therefore, you really have no control. Maybe that's what I'm trying to say. You really have no control over your practice. And that I think is the obvious disadvantage of being first generation.
Sir, we are also joined by a number of junior members from the center. If there's any question that anyone else wants to ask.
Yeah, feel free.
Sir, I don't think there's a question. Sir, we thank you for taking out the time to have this interview with us. Thank you so much, sir. It was great to have you here.
Thanks for having me. Bye.
Thank you so much.